All rise. The International Criminal Court is now in session, hosting the ICC Moot Court Competition 2026 Chinese edition. Please be seated.
Good morning. Good morning, everyone. Okay. I'd like to greet the teams participating. First of all, counsel for the defendant, and counsel for the government, and counsel for the office of the prosecutor. I welcome as well the courtroom staff and the security officers, and then the participants in the ICC Moot Court competition attending this hearing, and those outside the courtroom joining us this morning via the internet in the Moot Court competition. I now turn to the court officer and ask that she calls the case, please.
Thank you. We are sitting in the appeals session regarding the pretrial chamber's confirmation of charges in the case of the prosecutor versus Dragana Cyrax in the situation of the state of Essos, ICC Moot Court Competition 2026 Chinese edition.
Thank you, court officer. And now, on behalf of the chamber, I now ask the parties and participants in this hearing to introduce themselves, beginning with the counsel for the defendant, which brings this appeal.
与我的研究员葛云香一同代表赛队26022出庭。
Thank you. I now turn to the counsel for the government participating under Article 19 and 17 of the Rome Statute. Could I ask you, counsel, to present the members of your team?
谢谢法官。我是26014赛队的政府方律师陈泰文，这是我的同事陈柏珍，这是我的同事龚轩，这是我的同事郝春元，这是我的同事于青青。
Interpreters, nothing went out to the English channel. I think you may have been.
Now, can you hear me? Sorry, can you hear me? Yeah.
Counsel, could I ask you again to introduce yourselves?
No problem. Thank you, Your Honors. I'm representing the government, Mr. Chen, on behalf of Team 26014. My colleagues are here: Chen Bozhen, Gong Xuan, Hao Chunyun, and Yu Qingqing. Thank you.
Now, I turn to the counsel for the office of the prosecutor. Could I ask you to present the members of your team?
尊敬的各位法官，
Distinguished honors,
108号赛队
we are the Team 26018. My name's Fan Bingqian. My colleagues are here: Liu Meirui.
For the record, I'd like to say the team of the registry is represented today by the court officers, including Mr. John Cho, Mr. Mu Kiao, and Mr. Jiesheng Chao. Finally, I'd like to introduce the bench. To my right is Mr. Victor Sibaja, and to my left, Ms. Alisa Poinaru, and I'm Judge Ki Bongbek, and will be presiding this hearing. Now, the chamber will now proceed consecutively with the three issues shaping the subject matter of today's hearing. And being mindful of the public nature of this hearing, I'd ask the court officer to please read the agenda established by the appeals chamber.
Thank you, Mr. President. Pursuant to the pretrial chamber 15's decision to grant the defense's request for leave to appeal the confirmation of charges of 15 September 2025, the appeals chamber seeks submissions of the parties and participants on the following 3 issues. A, whether the pretrial chamber erred in concluding that the prosecution had established substantial grounds to believe that the defendant, Dragana Cyrex, ordered the war crime of directing attacks against the humanitarian mission within the jurisdiction of the ICC under Articles 8(2)b, Roman 3, and 25(3)b of the Rome Statute. B, whether the pretrial chamber erred in concluding that the defendant could be tried by the ICC, notwithstanding her status as the head of state of Marine. C, whether the pretrial chamber erred in rejecting the defendant's argument that the case must be dismissed because of the irregular means of her rendition.
Thank you, court officer. So before we start, I'd like to ask the parties and participants to speak slowly and then pause before responding to any question in order to allow all parties and participants to follow closely. And in addition, I'd like to remind the parties and participants that 20 minutes will be given for time of your presentation. And I'll now turn to the defense to present its submissions on the 3 issues of the discussion elaborated by the court officer. Thank you.
Your Honors, good morning. My name is Fan Xingrui, representing the defense. Together with my researcher, Ge Yingxiang, on behalf of Team 26022. This case began with a missing aircraft. It began with a deliberate hijacking. More fundamentally, it began with an attempt to circumvent legal process. Each of these events departs from a basic principle on which the legitimacy of this court depends, i.e., justice must be administered within the limits of law. In light of the decision of pretrial chamber 15 confirming the charges, the defense respectfully advances 3 grounds of appeal. First, this court has no jurisdiction over President Cyrex. Second, this court has no authority to remove or waive the immunity of a head of state. Third, the arrest and rendition process in this case violated the Rome statutes, seriously infringed human rights and state sovereignty, therefore undermine the integrity of the judicial process of this court. For these 3 reasons, the defense respectfully requests this chamber to allow the appeal and dismiss the case. Regarding the first issue, we have the following submissions. According to Article 2A, the court's jurisdiction is based on the place where the conduct occurred. The alleged conduct must have taken place on the territory of a state party. In this case, the conduct in question is the tracer rounds fired. It's fired beyond the territory of SS. Referencing Island of Pons of 1922 at paragraph A38 and ICJ case in the fisheries case 1951 at paragraph 133. both confirm that territory is limited to areas over which a state exercises full sovereignty, such as internal waters and the territorial sea. In this case, the conduct in question were fired 15 nautical miles from the coast. Although this location was within the contiguous zone of access, but there's no sovereignty here for a particular state. Therefore, it's not a territory of the state in question. So, the firing of tracers rounds did not occur within the territory of a state party. So, the court does not have any jurisdiction.
Thank you for your submission, counsel. I have a question for you. Would you please describe to the bench what the difference between the jurisdiction enjoyed in the exclusive economical zone and the territorial waters is for the purposes of this case, please?
Your Honors, a state, in terms of its exclusive economic zone, has limited rights. In light of UNCLOS, in light of Article 55, 56 and 58, other states in this zone also enjoys the rights of navigation and flyover or laying of marine cables and other legitimate uses. On the other hand, a state within its sovereignty is exclusive. So, in terms of these rights over the territorial sea, and especially in EEZ, is jointly enjoyed. So we cannot say that a state enjoys sovereignty in EEZ. This is what I would like to respond to you in terms of this question. Let me come back to issue 1 of my case. With regard to the subject matter jurisdiction, we don't think this court has this kind of jurisdiction here, because a non-lethal tracer rounds does not constitute an attack, and Dothraki cargo ship was not there doing humanitarian aid. First, in terms of attacks, in Abu Ghada 2010,
paragraph 65 and paragraph 101 of the judgment. In Taganda, this court adopted the definition of attack given in Article 49.1 of the Additional Protocol 1 to the Geneva Conventions, namely an act of violence against an adversary, and the court emphasized that the conduct must be of a violent nature. Now, when determining violence, you can look at the two dimensions, namely the acts and the results. Now, in terms of the means employed, the Marine Navy used non-lethal tracer rounds in the case at hand. The trajectory, in addition, also shows that this act was not of a violent nature, as well as the fact that it was non-lethal tracer rounds. Secondly, when it comes to the results, the Marine Navy did not actually cause any damage to Dothraki shipping, or indeed human casualties or injury. Therefore, the firing of non-lethal tracer rounds is not an act of a violent nature. Indeed, the act of the Marine Navy was of a warning nature. In 1999, Saiga number 2, Article 100, paragraph 156, there was specific reference given to warnings given in particular by wireless transmission, an oral warning and so on, which are preparatory measures but not violent measures. Now, after the issuing of wireless and oral warnings, a warning was then given by non-lethal means, and this does not constitute a violent act. Secondly, when it comes to the humanitarian mission, the defense would submit that indeed the international situation was unstable, but this should be fully taken into account by the international community. However, the Rome Statute does not protect every operation that merely claims to be humanitarian. Article 8(2)(b), subparagraph 3, protects only humanitarian assistance missions conducted in accordance with the Charter of the United Nations and in line with the United Nations GA Resolution 46/182. Humanitarian assistance must comply with the principle of neutrality in light of international humanitarian practice. Neutrality must be assessed by reference to the objective characteristics of the operation. Now, in this case, the Dothraki cargo ship on its mission lacked neutrality. Firstly, the ship came from an ally of Essos. The conflict between Meereen and Essos arose from ethnic tensions which had accumulated over centuries. Dothraki, as a state with a similar ethnic background to Essos and in alliance with it, had an obvious connection of interest with one party to the conflict. Secondly, the Dothraki cargo ship lacked objective indications of neutrality. Firstly, the vessel was not supervised by any neutral organization, nor is there any evidence that it communicated with Meereen regarding its time of sailing or its route. Secondly, the ship was an ordinary private commercial vessel flying its national flag without any marking indicative of a humanitarian status. Thirdly, the Dothraki cargo ship only made a unilateral oral radio declaration that it was engaged in a humanitarian mission when it approached the blockade line, and it even attempted to run the blockade. For these reasons, the Dothraki cargo ship is different from typical humanitarian assistance operations in international practice, such as UN cross-border assistance operations in Syria. It doesn't constitute a humanitarian assistance mission protected by the Rome Statute. If their honours do not have any other questions, the defence proposes to move to the second issue, the second ground of appeal. The question before the court is whether or not official status as a head of state precludes the exercise of jurisdiction by this court. The defense would submit that the only conclusion that can be derived from two objective facts is that jurisdiction cannot be exercised. Firstly, paragraph 14 of the record states that Meereen is not a state party to the Rome Statute. Article 27 of the statute excludes immunities based on official capacity, but it's an internal treaty provision. Under Article 34 of the Vienna Convention on the Law of Treaties, a treaty cannot create obligations for a third state without its consent. Article 27, if it were to be applied in the present case, would create an obligation for a third party, namely Marine, to waive the immunity of its head of state. Secondly, paragraph 9 of the record states that this case has not been referred to the court by the UNSC. It is true that international judicial practice shows that UNSC authorization may create a vertical relationship between an international criminal tribunal and a non-state party, but this case is not such a case. Unlike the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal on Rwanda, this court was not established as a subsidiary organ of the Security Council under Chapter 7 of the United Nations Charter, nor was its establishment specially authorized by the UNSC. Second, in the case at hand, the UNSC did not, in fact, refer the situation to this court. Therefore, the exceptional situation of a Security Council referral does not apply and cannot be relied upon to deprive President Chirac of head of state immunity. If the court has no other questions, the defense proposes to move to the third issue at hand. The third ground of appeal is as follows. President Chirac was hijacked on an aircraft, forcibly sedated and taken to The Hague while unconscious. These acts were not simply an irregular rendition. This was, in fact, a deliberate abduction. The question before this court is whether the court should allow its jurisdiction to be founded upon an unlawful abduction. The defense would submit that this court should not tolerate an unlawful abduction. Otherwise, it would lead to serious damage to both the legality and the legitimacy of the ICC. Firstly, if the court proceeds to try President Chirac on the basis of an unlawful arrest, the integrity of the judicial process will be impaired. As established by this court in Lubanga 2006, paragraph 39, and also by the ICTR in Barayagwiza, these both being precedents, where procedural illegality is so serious that it irreparably damages the integrity of the judicial process, the court must stay the proceedings. This case indeed falls under the same kind of serious circumstances. Firstly, the unlawful arrest constitutes a serious procedural violation. The Rome Statute, under Articles 89 and 91, states that a state party must receive a formal request for rendition or extradition from the court and complete the rendition through lawful procedures. In this case, the procedural safeguards were bypassed or circumvented. In the case at hand, Dothraki replaced cooperation with compulsive measures, replaced extradition with abduction, and the cooperation regime established by the Rome Statute was thus rendered meaningless, with serious damage to the legitimacy of the judicial process. Secondly, the unlawful arrest was sufficiently serious to cause irreparable damage to the integrity of the judicial process because it violated human rights and state sovereignty. I would like to ask you the following question. What is the connection with the Lubanga case when it comes to the case at hand?
尊敬的法庭，
Your
在
Honours,
卢班嘎案中，涉
in
及
the
到了
Lubanga case,
程序性的
there were multiple instances of procedural irregularities,
这些
and
程序性的违
in
法
order to
是否足以
solve
使
the
本院驳回
question
本案？
of whether the procedural irregularities
本院在
were
2006
sufficient to
年的上
affect
诉分庭的议
the
词中
court's
做出了
jurisdiction,
如下陈述：
the court in its appeal decision in 2006
当时有罪不罚的目标固然重要，但它不能够
stated
建立
that
在对于司法程序正当性的
it is important to
因此，我们依据
establish that
卢班嘎案中
there is no crime without punishment, but that is not in its own right sufficient to
在本案中正是涉及到
overturn
这
the
种程度的司法程序正当
degree
性的
of
侵害。
illegality and damage to the integrity of the judicial process,
我将
and
回到第三项
thus
上述
the
议题
court rejected jurisdiction. I will now return to the
本
case
案中的
at hand. Secondly, the
严重的
unlawful
侵犯
arrest in
被
this
告
case
人
was sufficiently
塞
serious
拉
to
斯总统遭受非法劫
violate
持
the human rights
强
of
制麻醉
President
被秘密的代理本
Sirax, who was anesthetized,
公民权益
abducted
和公民权益国际
by
公约
force, and rendered
条所享受的
to
人身自由权受到严重的侵犯。
another territory, and thus seriously violating her rights under Article 5 of the International
已经
Declaration of
严
Human
重地
Rights.
侵犯了梅林的国家主权。
Furthermore,
参照
there
国
has
际法
been
院
serious
2002
violation of
在 arrest warrant 案第
state sovereignty of the states of Marine. In
2008年
the ICJ judgment in the warrant case, paragraph 54 in 2006, and Djibouti versus France,
联合国外交
paragraph
和豁免公约
170,
第11节
as well as in line with Article 11 of the Convention on Privileges and Immunities of the United Nations, a head of state
享有
is a symbol of state sovereignty and enjoys
塞拉斯
personal
总统
inviolability.
在参加
Therefore,
联合国的会
the
议的途中
unlawful abduction of President Sarax while
无异于
she was
对于
traveling
美
to
国家主权的公然
attend a United Nations meeting amounts to a direct violation
交程序
of the
违反
principle
规约规定
of sovereign
侵犯
equality.
人权与国家主权
For this reason, the rendition process in the case at hand seriously violated the Rome Statute, human rights and state sovereignty, and the court should stay
应当接
the
受其他的
proceedings.
代替性救济手段，
Second,
否则法
the
院
defense
的
submits that the court must not accept alternative remedies, or else the legitimacy of the ICC will be seriously damaged. The legitimacy of a court depends on the confidence of the international community in its judicial fairness. As a treaty-based court,
而建立的法庭，
the authority of the ICC does not rest
应
on
该来自于强
coercive power.
而是来自于公平审
Indeed,
判、
it rests
程序
on
正义
procedural justice, fair trial
国际
rights,
社会
and
及依法
the
行使
recognition
国家权
of
的
the international community that the court exercises its jurisdiction
案双方
according to law. In this case, neither of the parties involved is a state party to the Rome Statute. If the court nonetheless accepts
的绑架之上，
jurisdiction founded upon an unlawful
将给国际
abduction,
社会
this
释放一个
would send a dangerous signal to the international community.
缔约国一方面
The signal would be that non-state parties may avoid the cooperation and rendition procedures under the Rome Statute
却可以利用
while
规约的机制
still
来达成自身的
using
政治目的，
the state's mechanisms to pursue their
而
own
一旦给
political
国际社会
objectives.
留下这样的印象，
Once this impression has been created for the international community,
依法行使
the
司法
trust
权
and
的
respect that this court should enjoy as an independent international criminal tribunal acting
也
according
将
to law
不可避免地
will
受到
be
损害。
inevitably weakened.
实际上，国际社会
Indeed,
不缺乏
the
具有高度争议性的
international community has already seen highly
是他国领导
controversial examples of cross-border enforcement actions aimed at controlling the leaders of other states, such as the so-called Operation Absolute Resolve conducted by the USA against Venezuela earlier this year. This court tolerates this kind of procedural illegality. It will further encourage states to use unlawful arrest and abduction as tools to obtain ICC jurisdiction. This will, on the one hand, weaken the state cooperation regime established by the Rome Statute, but also raise serious doubts as to this court's legitimacy. Therefore, in order to protect the legitimacy of the ICC, the court should not adopt alternative remedies such as sentence mitigation or compensation. Your Honours, at the end of its submissions, the defence respectfully reiterates that ending impunity is undoubtedly important. However, as the appeals chamber of this court held in Lubanga in 2006, paragraph 39, that objective must not prevail over the justice of the judicial process. Accordingly, the decision of the pre-trial chamber confirming the charges should not rest on an excessive expansion of jurisdiction. It shouldn't rest on the removal of the immunity of a head of state of a non-state party, and it should not rest on the tolerance of an unlawful arrest. For all of the above reasons, the defence respectfully requests this court to render a just decision and dismiss the case at hand. Thank you, Your Honours.
Thank you, Counsel. And I will now give the floor to the Counsel for the Government to discuss the issues on the agenda of this hearing. You have the floor, please.
尊敬的法庭，各位带着正义之心来到法庭的朋友们，
Your Honours, colleagues, and all those interested in justice, my name is Cheng Taiwan, and together with my colleagues, I represent the government of the state of Marine.
在进行正式的意见陈述之前，政府方需要先说明与辩方之间的区别。
We would like to share our differences between the government and defense, and we have the common grounds, but we have different ways to prove. And the government agrees with some submissions with the defense, but we will elaborate more from the perspective of a Marine. We have the 4 submissions. And first, Marine should participate in this proceeding as interested states and not amicus curiae. And second, the ICC doesn't have jurisdiction. And third, the court doesn't have enough grounds to believe that the Marine has committed a war crime and have criminal responsibilities. And fourth, the court shouldn't set aside immunity of a head of state. And last, the case should be dismissed on the grounds of unlawful rendition. First of all, the Marine should participate in proceedings as interested party in order to protect its proceedings right. And first of all, I would like to talk about the differences between interested states and amicus curiae. Interested states can protect a state's interest. The more importantly, according to the Article 17 and 19, the Marine can challenge the jurisdiction of ICC. Marine can also challenge the admissibility of ICC. And however, the rights enjoyed by amicus curiae are limited. According to the Article 103 of the Rules of Procedure and Evidence, the amicus curiae can only share submissions in a limited range. So the amicus curiae cannot meet the procedure demands of Marine in this case. And we have jurisprudence. For example, in Gaddafi case, Libya formally entered the proceedings as a state challenging admissibility under Article 19 of the statute rather than a amicus curiae. This shows that when the proceedings have problems, the country can have independent procedural standing. And at the same time, the countries can challenge the court. And ICC needs that Marine accepts its jurisdiction. And this is the most important condition. But the Marine has never accepted jurisdiction of the ICC. So the ICC should accept that the Marine participates in the proceedings as interested states. The second submission is the ICC doesn't have jurisdiction in this case. First of all, the ICC cannot have jurisdiction based on the nationality of Cyrax, because ICC is not a state party of the Rome Statute, and Marine has never accepted the ICC jurisdiction. And the ICC doesn't have a territorial jurisdiction over Marine. And we will further elaborate on territorial jurisdiction under Rome Statute. First of all, the ICC territorial jurisdiction has never accepted a fact doctrine or a fact principle. The acts should happen in a state party, but when acts happen beyond the state party, and ICC doesn't have explicit explanations or jurisprudence to prove when act happens beyond a territory of the country, the ICC can have jurisdiction or not. And we cannot over-interpret the territorial jurisdiction of ICC. And when the definition is not clear, and we need to interpret the clear, and that should be in favor of defense. And when we shouldn't overly interpret the acts, but in this case, ICC doesn't have explicit explanations, and this is not in favor of defense. In ICC's under ICC, there's differences between acts and consequences. First of all, there's an element of intent. And second, there's a standards for intent. So we shouldn't mix the acts and consequences. And I would like to talk about a jurisprudence. For example, in the case of Myanmar and Bangladesh, if there's one element and happens in the territory of the state party, and there will be territorial jurisdiction. But all the elements in this case haven't happened in the territory of the state party. So it's very different from the Myanmar and Bangladesh case, because in Myanmar and Bangladesh there's element of transboundary, but in this case we do not have this element. Thus, the ICC doesn't have jurisdiction over this case. And the third submission is that there is no sufficient ground to believe that the accused has committed war crime.
I have a question for you. So you just stated that the crime discussed in the Bangladesh case, that crime is transboundary and the crime in this case is not transboundary. Could you please explain why you consider that to be the case? Thank you.
好的，感谢法官的提问。
Thank you for your question.
罗马规约在犯罪要件这一附属文件当中详细阐述
In the
项犯罪
elements of Rome statutes, we can see very clear explanation of elements. In the Myanmar case, there were
将人口非法的驱赶进入
is the people are not allowed to enter other countries and territory. So in that case, that's Bangladesh.
而在本案当中，
But in this case,
载着一艘货船或者
the cargo ship
进入到
or the humanitarian aid
辖的领土范围之内，
doesn't enter into a territory under ICC jurisdiction. Thus, the ICC doesn't have jurisdiction in this case.
在此基础之上，政府方律师将继续阐释
And we will continue
客观要件的反驳。在本案当中，犯罪的客
on
观
the
要件
objective element.
因
In
为
this case, the objective elements are not met
上的攻击，
because
第一附加
the
理书
objective element of this offense doesn't being satisfied.
针对对方实施的暴力行为，
The attack means an act of violence and
特别法
against adversary.
均指出，
In the ISIS case,
实际造
the Special Court for Sierra Leone held that an act of violence must constitute coercive interference that endangers physical safety or restricts personal liberty. And this
人身安全
focuses on
人身自由的强制性干涉，
the safety issue. In this present case,
即通过无线电通知船只，
the Marine has used the tracer rounds to warn the ships,
采用了克制的手段，
and they have used other means to
击伤船舶，
launch the non-lethal
航线。
rounds.
这说明梅林的行动
This
和海上执法中
intends to convince the ship to divert from the initial course. So there's not an act of violence.
国际海洋法法庭在塞加号案中指出，海上拦截应当
The International Court of Law of
发
Sea
出声音或者视觉信号。
and has
这正如梅林
elaborates on the procedure of launching warnings. First of all,
可以向船首
the ship can send
证实梅林
a radio warning,
采取的
and if there's no response,
而在这些措施
the ship can send a tracer round to continue to launch the warning. If all those means do not work, the final resort is violence. But in this case, the Marine has never used violence as the last resort.
适用的圣雷莫手册当中也规定了警告与攻击的区别。突破封锁的船只
And in many other
先受到
international legal instruments, we can see the differences between warning and attack.
能进一步受到攻击。在本
When the warnings are rejected by when the warnings are rejected by a ship, and the attack
梅林海军
can
所采取
proceed.
是符
So
合海上武装冲突国际法
the Marine has used
所实施的
the customary means or blockade
法行为，在此基础
accepted by international community.
军的释法行为认定为破坏
In these circumstances, we cannot consider that the acts of Marine are considered to be an act of violence or against the Rome Statute.
在完成了对于客观要件的论述之后，政府方想要强调
Now,
罪的主观要件
I would like to insist on the objective elements.
Thank you for your submissions. And I have one question about the attacks. And here, well, you can see in terms of violence, the Marine, the Navy was deployed and they occupied the area and they gave a warning. So maybe the combination of the Marines' location and plus the warning can be wholly categorized as a violence. What do you think of this idea? And I believe the defense counsel, at the opportunity of rebuttal, will respond to my question as well.
"对不起，法官，我没有太听懂这个。
Could you please repeat your question?
Yes, you talked about the warning, but here there are two facts. One is the location or deployment of a Marine and Navy on the sea, and they gave a warning. So when you combine these two factors, the Marine was located and blocked, and they gave a warning. And in total, this can be categorized as a violence. What do you think about this idea?
感谢法官。
Thank you. I understand perfectly your argument, but for the government, we do not agree with your argument. We don't think there's act of violence. For example, in the international document, and there's a definition about blockade. And then we can see how the blockade can proceed. And the Marines' way of doing is as the international document states. So it's violent from objective point of view because it's done by the Marine Navy, but it's not an act of violence under Rome Statute's definition. We will continue on the subjective element, and we are very different from the defense. Whether it's a humanitarian assistance or not, it's not the most important point in this case. The most important is when a Marine decides to attack, whether it knows it's the ship cargo for humanitarian assistance. According to the Article 30 of Rome Statute and the crime element, the defendant should know the ship is for humanitarian assistance and attack is on the personnel or materials of humanitarian assistance. So we should prove this ship is doing the mission of humanitarian assistance. But we have doubts on the humanitarian nature of the ship. We have three reasons. First of all, it's a private jet. It's a private ship of a Turaki. So there is not a Red Cross sign of humanitarian assistance or cargo. So from outside, we cannot decide whether this ship is carrying a humanitarian mission. Second of all, the Turaki is a close ally with ASUS. So we have questions about neutrality of this mission. Third of all, this ship has been warned by Marine. This ship doesn't use radio to communicate with Marine Navy in order to share more about its mission. The ship doesn't say that it's doing a humanitarian mission and they are carrying medicine. So the Turaki, the private ship, doesn't communicate with Marine. So this ship has run the blockade to continue its course. That's why this mission is out of control. In this situation, the Marine Navy cannot decide whether this ship is doing the mission of humanitarian assistance.
主观的认识内容当中，也不包含该船舶具有人道主义援助的性质。因此，
And we do not know whether this ship has humanitarian nature. That's why, from subjective perspective, we cannot decide this ship is doing the mission of humanitarian assistance.
实施规约第82B3条规定的战争罪，也即不应承担第253B 条的。
And the Cyrex doesn't order the war crime.
I'm sorry, counsel, to interrupt. I just had a question because from the facts of the case, it appears to the bench that the ship announced its humanitarian character. It announced that it was carrying supplies. Is that not sufficient notice to fulfill the article that you were talking about?
好的，这一点并不足以。
We don't think that this point is enough because,
的判例，在
according to Rome Statute and ICC jurisprudence,
认识到的事实情况作为依据，
the person should
解决本案的被告
know the humanitarian nature of the ship, and the present Cyrex
得到通知，该船只是
has never been informed that this ship
货船，
is
该船只通过无线电
doing a mission of humanitarian assistance,
是单方面的宣布，
and this ship sent a radio message, but it's just a unilateral announce. It doesn't have any proofs. And after the tracer round, the ship doesn't show on its cooperation position.
更加值得怀疑。
So we raise more doubts on the humanitarian nature of the ship.
好，在此基础之上，对于责任层面进行进一步的说明。
Now I'd like to elaborate more on the responsibility
布达库穆拉案，刑事责任
point.
要求行为人具有权威地位，发出命令，并且命令对犯罪具有直接影响，并意识到犯罪会在通常事态中发生。而在本案当中，
In this
被
case,
告有充分理由相信其海军会依法执行命令。
the government doesn't dispute the first criteria as president and commander-in-chief of the armed force. And Cyrex naturally holds a position of general authority.
下面我将陈述第4项法律意见。
We would like to elaborate the fourth submission
受豁免权
is the immunity of the head of state. And we have two
第
reasons.
27条
And first of all,
排除本案中的国家元首豁免
Article 27 should not remove immunity
是条约
because
戴普林案
ICC is a
刑事
treaty-based
与国家元
court.
首豁免权是两个
And
不同的问题。即便法院
These are two different questions. Even if
与辩法院享有管
ICC enjoys jurisdiction, this doesn't mean the immunity enjoyed disappears automatically. So we have to abide by Article 12 to acquire jurisdiction. Then we can discuss about the waiving of immunity. But in the case at hand, Marin never waived immunity and they never cooperated with the court. They never accept its jurisdiction. So in this case, the head of state of Marin still enjoys her immunity.
然后政府方想要强调
Secondly,
强行法的问题，
in terms of Jews' cogence,
也不可以
Jews' cogence cannot exclude immunity of head of state for two reasons. First, in this case,
并不当然具有
war crime does not enjoy necessarily the nature of Jews' cogence because there are still disputes with regard to attacks. So this is not necessarily Jews' cogence. Secondly, even if it's Jews' cogence,
规则，也不自动排除
it does not automatically preclude immunity procedurally.
陈述最后一项法
Now, I'd like to talk about the last submissions.
陈述违法，驳回本案。
If the court should dismiss a case due to procedural irregularities, first,
规约的
the arrest and rendition is wrong. So,
任意的逮捕，
Article 9 of ICCPR forbids unlawful, arbitrary detention or arrest. Dokmanovich also held similar submissions. So in this particular case, the defendant was arrested, and this circumvented the normal procedure. Secondly, in Baryakzaviza, the court held that if there are serious irregularities, the court should dismiss the case because of the procedural irregularities. So this can result in dismissing of a case. In particular, in this particular case, this is related to the Office of Prosecution. So in April 2006, an arrest and warrant of arrest has been issued, and ICC decided that ICC expected the warrant of arrest to be executed so as to arrest the defendant so that he or she can be tried by the court. So Dothraki in this particular case has a logical connection with the court. So ICC is related to procedural irregularities which are serious enough, which can reach the standard of dismissing the case. So the rendition procedure is totally irregular and violated human rights and procedural fair trial. Other remedies are not enough. Therefore, the court should state the procedure and dismiss the case. So, Your Honors, please consider our submissions and make the right decision. Thank you.
Thank you, Counsel, for the government. And I have one question, but since the time is over, you can make a response to my question in your rebuttal chance. So, in your regarding the first issue, you mentioned the limited role of the amicus curiae, and which is totally different from the standing of the government. And I want to you elaborate more on which point the role of the amicus curiae is limited. And I'd be happy to hear any examples that the government can do, but as a party, but the amicus curiae cannot do. Thank you. And now I turn to give the floor to the Office of the Prosecutor. You have the floor.
Your Honors, the defense, hi, good morning, the defense and government counsels. I'm from 26018 team. I'm Fang Bingchen and my colleague Liu Mirei. According to the decision rendered by Pretrial Chamber 15, in today's appeal proceedings, as the prosecution, we want to talk about three disputed issues in this case as follows. First, the defendant ordered the war crime in terms of A2B3 and 225(3)B, obstructing humanitarian medical aid. So this is within the jurisdiction of the court. Secondly, the defendant is a sitting head of state, but she can be tried by ICC or this court. Third, the defendant, in terms of her rendition irregularity, and this case should be dismissed. This should not be accepted. So issue one, we think, pursuant to Article 12 of the statutes, ICC enjoys territorial jurisdiction. The core of territorial jurisdiction is that the conduct in question takes place within territory of a state party. And also Article 31 of VCLT says when interpreting the statutes, it shall be construed in good faith, in accordance with the ordinary meaning of the terms, within their context, and in the light of statute's object and purpose. And the Article 12 of the statutes stipulates that the conduct is related or even same as the effects. Because first of all, in terms of textual interpretation, the OED says the term context covers results of combined actions. This conclusion is also backed by the official French version of the statute. The French term comportement covers acts as well as their observable objective effects. Second, based on the method of systemic interpretation and combined with Article 12 of the statute, the phrase conduct in question and crime are used separately in two paragraphs to determine whether the ICC has territorial jurisdiction, so that the two terms bear the same meaning. Therefore, jurisdiction isn't merely based on the acts. Lastly, based on the method of interpretation in light of object and purpose, including effects within conduct in question, fits the object and purpose of the statutes of punishing the gravest crimes. The defendant's blockade in this case left hundreds or even thousands of children in Essex suffering from loss epidemic. Combining the above interpretation methods, the effects arising from the blockade occurred within Essex. So, the ICC has territorial jurisdiction over this case. Second, the defendant's conduct constitutes a war crime of impeding the delivery of essential medical aid under Article.
I have a question. So, you said that the effects of the conduct, as I understand it, they took place on the territory of a state party. I'm just wondering, my understanding of the case is that this attack took outside the territorial waters of this state. So why in your submission that falls within the concept of the territory of a state in this case? Thank you.
Thank you, Your Honor, for your question. The attack, as you said, occurred outside the territory of Essex, but the effects, as we see it legally, and we can also reference the effects principle of the anti-monopoly laws. It's direct, predictable, and substantial effects or reaction. So, combining with blockade, we can see direct, predictable, and substantial effects here, i.e., medical supplies are not transported into the territory of Essex, which caused the epidemic to worsen. So these effects, in terms of its legal effects, happened. So it's on the territory of Essex. So this should be taken into consideration here.
Sorry, usually I don't have ask a follow-up question, but this is a very interesting topic. And in terms of the effect, there can be an argument that the direct effect and indirect effect, and you mentioned the direct and the foreseeable effect happen. But when you analyze more closely, the direct effect is the blockade of the cargo ship. The cargo ship couldn't enter. And if, for example, the direct violence happened, then somebody in the cargo ship or the cargo ship itself may have been injured or damaged. But here, the effect happened not on the cargo ship, but in the country of the Essex. So this, nevertheless, this effect, which can be also categorized not direct but indirect effect, can be included in the scope of effect, which will be contributive to the establishment of jurisdiction. So you can give more elaboration about your reasoning why and how this effect, which happened in the remotely from the cargo ship, can be considered as a element of these factors to be considered to constitute the territorial jurisdiction.
First of all, with regard to your consideration, on the cargo, there wasn't direct effect. Maybe you think that the effects within assets are indirect. So in this consideration, the prosecution holds that we should talk about legal effects, i.e., the effects being that medical supplies are not transported into assets. And in other similar cases, for example, Abu Garda, in jurisdiction, the court held with regard to attacks on special mission, which leads to the medical supply not being transported into zones or areas, then the court should take into consideration the population without help or without assistance. So combining the prosecution arguments, we have to take into consideration those populations which did not get their medical supplies or assistance. Now, I'd like to talk about the objective elements of war crime. First of all, according to First Protocol, Article 14 of Additional Protocol 1, attack means acts of violence. And Ntaganda case interpreted violence further and said that regardless of the type, means any act that carries a potential damage risk can be qualified as acts of violence. In this case, the perpetrator fired non-lethal tracer rounds, thereby completing an attack that created the potential risk of injury to personnel from Dothraki cargo ship. So, direct attack here. Secondly, the assistance in the present case is carried out in accordance with the Charter. Humanitarian assistance is added to an affected population, and which is important for the local population's well-being. And this should abide by UN Charter, its purpose and principle. The transportation held by Dothraki fully accords with the purpose set forth in Article 1 of the Charter, namely to ensure respect for the right to life and health of children within access, and to rescue up to hundreds of thousands of access people from facing a lifetime of pain and disability. Next, turning to the subject element. In the present case, the perpetrator, with knowledge of the pre-existing armed conflict involving airstrikes and the factual protected status of the targets, intentionally direct attacks against multinational vessels conducting humanitarian assistance. And the president also refused to break a blockade, like paragraph 12. So it attacked multiple multinational vessels which satisfy the subject elements of a war crime. In the end, concerning the individual criminal liability, in Sylvester...
Sorry, I have a question. I'm just wondering, considering the government's submissions on this point of the subjective element, and I believe as well that that accords with the defense's submission on this point, that there were no clear indications of the neutrality of this cargo ship, and accordingly there were doubts about this ship being protected. What is your response or view in respect to those specific submissions made by the government and the defense on the mental element and the doubts arising from these factual aspects that I just mentioned? Thank you.
The prosecution totally understands your concern, i.e., there is no clear marking on Dothraki cargo ship. Then Marine, how can the Marine handle this ship? For us, the government and the defense also mentioned the San Remo manual, but not completely, because in San Remo manual, articles are very clear about the blockading party should make sure supplies be transported smoothly. And in the substance of this case, the authority were transporting medical supplies and informed that they were transporting medical supplies to the concerned parties, even without, for example, by marine. They can abide by San Remo manual to, for example, carry out a search to make sure that the population can acquire these very important medical supplies. They had doubt, but they didn't carry out searches, and they just chase away the ship, or they threatened with violence. This was totally inappropriate. Then, with regard to individual criminal liability, in the Sylvester Matakumura case, ICC held that ordering as a mode of liability under Article 25(3)(b) of the statute requires that A, the person is in a position of authority. B, the order of the perpetrator will cause the occurrence of the criminal act. C, the order had a direct effect on the commission or the crime. And D, the person is at least aware that the crime will be committed in the ordinary course of events. In this case, the defendant, acting as president and commander-in-chief, held a position of authority and explicitly ordered the continuation of naval blockade. Acting with full knowledge of the armed conflict and the deteriorating epidemic situation, the defendant's order direct caused the captain to fire tracer rounds, producing an actual effect that impeded medical assistance. On the second issue, the prosecution submits that this court may exercise jurisdiction over the accused, notwithstanding her position as a head of state of Marine. First, head of state's immunity is grounded in the principle of the sovereign equality of states. By example, par imperium non habet imperium is a rule of customary international law. So horizontal, equal relations between states. So one country, the head of one state cannot be charged by another state. This is to prevent unlawful interference of other countries' sovereignty. The ICC, as an international criminal court, acting on behalf of the international community, and it's above this horizontal relation between states.
Thus, head of state immunity or interstate immunity applicable in horizontal relations between sovereign states does not apply. Secondly, customary international law recognizes an exception to head of state immunity before international tribunals prosecuting international crimes. Article 27 of the Rome Statute codifies the principle of the irrelevance of official capacity, providing that having an official position shall not exempt a person from criminal responsibility or bar the court from jurisdiction. Since the statute's entry into force in 2002, it has attracted 125 state parties, demonstrating the broad acceptance that heads of state enjoy no immunity before the ICC for international crimes. Finally, so far there's been no precedent in international criminal jurisprudence that head of state immunity is recognized before an international criminal tribunal. In the El-Bashir, Taylor, Orenzija and Milosevic cases, international courts and tribunals have affirmed that official capacity does not shield the accused. Thus, President Cyrax should not enjoy such immunity. On the third issue, the prosecution submits that the defense's submission based on alleged irregularities in the surrender process is without merit. The court should neither dismiss the case nor order the release of the accused. First, the jurisprudence of the ICC and other international criminal tribunals establishes that defects in arrest or surrender procedures do not deprive an international tribunal of jurisdiction. A stay of proceedings is warranted only where the irregularity renders a fair trial impossible. In Barayagwiza, the ICTR held that although there were concerns surrounding the accused's transfer, the proceedings should continue, emphasizing the fairness of the trial, which is to be balanced with the legality of the arrest. The ICTR adopted the same approach in Kajeli. Likewise, in Lubanga, the ICC Appeals Chamber held that whether irregularities in rendition or arrest affect the right to a fair trial must be assessed on a case-by-case basis, only where the accused's rights have been so seriously violated that a fair trial can no longer be guaranteed, may the proceedings be stayed. Where they cannot be properly defended on a legal basis. Now, in Barayagwiza, the appeals chamber acknowledged procedural irregularities, and the remedy it adopted was a sentence reduction on conviction. Furthermore, release of the accused is not an appropriate remedy. Referring again to Barayagwiza, the remedy adopted by the appeals chamber was sentence mitigation upon conviction, not the immediate release of the accused. In the Lubanga judgment, the ICC also cites Barayagwiza. Procedural defects cannot directly lead to release of the accused or stay of proceedings, and declining jurisdiction is not held to be an appropriate remedy. Furthermore, according to Article 85 of the Rome Statute, persons subjected to unlawful arrest or detention are entitled to compensation. The Lubanga judgment also states that victims deprived of liberty by unlawful arrest or detention can seek compensation under Article 85(1) of the statute. Therefore, there are multiple remedies available, given that the violation of the accused's rights has not reached an extreme level. The grounds for dismissing the case and releasing the accused lack reasonableness and necessity. Now, the prosecution also submits that we will neither overstep legal boundaries to pursue charges at the expense of the rights of the accused, nor allow grave crimes to go unpunished due to minor procedural irregularities. The prosecution remains committed to striking a balance between ending impunity and safeguarding the rights of the accused. Now, in international jurisprudence, it has not been held that illegal arrest but legitimate prosecution is a ground for releasing the accused. The court is able to claim jurisdiction. At the start of the 21st century, in Nikolichi, the ICTR held that the principle of bonus malus was also a relevant principle of international law, male captus bene detentus. Now, in addition, the reliance on minor procedural irregularities should not be a reason for declining jurisdiction. And the court has a clear duty to end impunity. We are not merely seeking a guilty verdict, but a system whereby all those who need to be brought to justice are brought to justice in an international forum, upholding the mission of enforcing international law under all circumstances. That concludes the submissions of the prosecution. Only when justice is firmly anchored in the rule of law can international criminal justice truly command the trust of the international community.
Thank you for the office of the prosecutor. And I believe the various and important points have been raised in the statements made by each of you parts and participants. And now we will go to the next round. So each party will be given 10 minutes for their rebuttal and in the same order. So now I will give the floor to the counsel for the defense. You have the floor.
Thank you once again to the court. The defense would like to offer the following 4 rebuttals to the prosecution's arguments. Firstly, the prosecution cannot merely rely on the non-lethality of tracer rounds to establish that there has been an attack. Secondly, they cannot rely on effects in order to establish territorial jurisdiction for the court. Thirdly, the prosecution cannot rely on cases such as al-Bashir to establish that the government is not an interested party. Finally, there have been sufficiently grave violations of human rights and international law to the degree that the court is entitled to reject the case. If the court so permits, I shall now expound on the first submission. Firstly, in response to their honour's question, Article 8 to 3 of the Rome Statute refers to acts of war in an international armed conflict. In particular, what it refers to is the ordering of an attack and whether that is appropriate. Now, when considering whether this offence had been committed, it must be considered whether the acts constitute an attack. We do not deny that there has been an armed attack, indeed an armed blockade. The critical element, however, is whether the acts were of a violent nature. In the entirety of this case, we would submit that the only act that is potentially of that nature is the firing of non-lethal tracer rounds. In Article 1889 of the judgment of the Sierra Leone Tribunal in 2009 it was clearly held that acts including violent behavior in the Sisi case could be held as violent. Now, in this case, this is a precedent of threatening with actual guns, but we consider that this case must not be considered in isolation. In Article 1890 to 1900 of the judgment, it is clearly laid out that these acts were held out. These acts were carried out when peacekeeping personnel were subjected to detention and beatings, and thus the threat of such actions was considered to be of a violent nature. This case, however, is different. The only acts in the case considered to be possibly of a violent nature are the firing of non-lethal tracer rounds. And so Abu Ghada and Ntaganda refer to acts of a higher degree and different means. We must refer to these in considering whether or not the acts in question are of a violent nature. We would submit that they are not. Now, it is submitted that there is a potential threat from non-lethal tracer rounds, and thus these acts are violent. However, in military practice, in order to ensure that acts of warning are able to achieve their effect, there must be a potential threat, or else they have no deterrent effect. In Kenya, Brazil, and Peru, military codes clearly state this, and thus the prosecution cannot argue that the threat as such carried by non-lethal tracer rounds demonstrates their violence. Secondly, the prosecution cannot rely on the effects doctrine in order to claim territorial jurisdiction. In judicial practice, this court has rejected that position. In the Myanmar situation, the court made a clear choice of charges to lay. In the United Nations report on Myanmar in 2018, it set out a number of crimes, war crimes, genocide, and crimes against humanity. However, the court finally laid charges only of unlawful deportation because it was unable to rely solely on the effect of actions, and thus the principle of effects cannot be relied on to claim territorial jurisdiction. Thirdly, the prosecution would rely on cases such as al-Bashir to claim that heads of states have no immunity, but such immunity is a principle of customary international law. If this court rejects that, then it will set a new precedent that head of state immunity does not apply in international criminal proceedings. However, in the Jordan appeal in 2019, the appeals chamber rejected that responsibility and held that head of state immunity was a principle that applied in that case. And we are of the view that both states parties and non-states parties, including the US, Russia, and China, as well as the African Union and the Arab League, major regional bodies, have supported that position. In the Special Tribunal for Ukraine, it has been recognized that heads of state enjoy immunity. In light of the above precedents, we are of the view that head of state immunity can be relied on before a tribunal such as this. Now, thirdly, the violations of rights, when combined, constitute grounds for this court to reject jurisdiction. We recognize that acts constituting torture have not taken place, but this does not mean that the human rights of the accused have not been gravely violated. President Cyrax was illegally abducted and rendered unconscious by forcible anesthesia. Forcible anesthesia is an extremely dangerous act, and her personal liberty was violated. This is a serious violation, and in previous cases there's no precedent for the illegal abduction of a head of state. This is an unprecedented violation of national sovereignty. Therefore, we would submit that the violations of rights are sufficiently grave. This concludes our submissions on the above points. Thank you.
Thank you. Now, the Counsel for the Government, you have the floor.
Your Honours, ladies and gentlemen, on behalf of the Government of Marine, we would like to respond first of all to the questions of their honours and the position of an amicus curiae in international litigation. Under Article 103, the amicus curiae is a role that is supportive of legal proceedings, and relevant countries under Articles 17 and Article 19 may have a procedural standing in cases in order to uphold their own national interests.
Amicus curiae can only be used as an outsider in this case, but the interest of the state can defend the government of Marine in this case. The government would like to insist that the Marine and defendant are two different definitions. The Marine has its own interest of state that need to be protected. It is not equated with individual responsibilities of the president. But the government of Marine insists on the protection of Marine Navy and interests of the population of Marine. It also protects the interests of the population of Iraq. So the Marine needs and is necessary to participate in the proceedings as interested state. In the case of Gaddafi, if Libya cannot participate in the proceedings, Libya cannot reply to the questions in the court, and for example, how Gaddafi has violated human rights, and how to distinguish Gaddafi's interest with the interest of Libya. This shows that Marine has the right to participate in the proceedings as interested state. This is my first rebuttal. Here's my second rebuttal. The prosecution has mentioned that Marines and government has the responsibility to provide free navigation to humanitarian assistance. We do not deny that we should offer free navigation to humanitarian assistance. However, when the ship is not allowed and the ship runs the blockade, it's not a peaceful act of cooperation. When the accident occurs, the commercial ship can stop. It can show its attitude of cooperation with the Marine. However, when the ship is rejected, it doesn't stop. It didn't further use radio messages to communicate with Marine Navy. On the contrary, this ship continues its course. It tried to transgress the blockade. We would like to insist that when the accident occurs, there's serious international conflicts. The ship doesn't cooperate, and the ship challenge the Navy. I think this should be alerted. Marines Navy has responsibility to create environment of cooperation. It's also the responsibility for the ship of humanitarian aid, because peace needs cooperation. In the practice of the UN in Gaza, so the humanitarian crisis, the UN has cooperated with Israel so to guarantee the delivery of humanitarian assistance. In 2024, the Vice President of Marine has already cancelled the blockade. It said that the blockade didn't have enough considerations. So this is an act of good faith. The Marine found that the humanitarian crisis is very serious, and Marine agrees to offer a special entry for humanitarian assistance. But we are very sad to see that in this case there is no cooperation. Our third rebuttal is as follows. The preceding defects are not that serious, and this case should be dismissed, and we disagree. We have already elaborated on violations of human rights, and the prosecution says we shouldn't use those arguments because no person has been tortured. But this doesn't prove that the acts on those victims, on the population, are appropriate, because the government of Marine doesn't only represent the interests of population. As a head of the state, the president of Marine represents also the image of a country. Imagine a head of state is abducted in the UN conference, and she has been sedated, and she has lost her consciousness. So she's deprived of freedom to exercise its function. It's a severe violation of human rights. So if the court doesn't dismiss the case, it will set a terrible precedent. So the other countries cannot believe the cooperation system under ICC, and we cannot guarantee the protection of the head of state. We need to further stress that in the case of ICC, for example, in those exceptions, we have valid historical reasons behind those cases that shouldn't be treated as customary international principle. And this the president doesn't order the war crime, there is no large casualties or harm. So it doesn't meet the criteria of the level of severity of acts. We have another rebuttal. In the chapter is written that peace is not easy, and people live together and cooperate with each other. But it's a very fragile peace. The ICC is a permanent court, and the ICC intends to protect international justice. In this case, the President Cyrax and Marine, and have suffered from injustice. And this has already had an impact on the population in Marine and on the population of Iraq. And this has also an impact on all the people believing in the UN. And they are asking themselves whether they should continue to believe in the UN and ICC. The Vice President has already cancelled the blockade, so the Marine has already sent the good faith. The justice should be based on peace and cooperation rather than the sanctions of a victim. And we should use correctly the law in order to save the case. So I would like to summarize. First of all, the government should participate in this proceeding as interested state. Second, the ICC doesn't have jurisdiction over the case. And third, the president of Marine and order the war crime under 8.2b and shouldn't shoulder responsibilities. And we shouldn't set the immunity of the head state aside. And this case needed to be dismissed. We would like to ask the court to adopt our opinions. Thank you, Your Honors.
Thank you, Counsel. And the last word is from the Office of the Prosecutor. You have the floor.
Your Honors, the prosecution will reply to the rebuttals of defense and the government. About the first issue, the defense counsel has quoted an effective principle. And according to the Vienna Convention on the Laws of Treaties, the territorial jurisdiction and has a factor doctrine or a factor principle. In the 56th paragraph, in the Myanmar case has already mentioned it about the territorial jurisdiction. We need to take into consideration, in fact, territorial jurisdiction, object territorial jurisdiction, and the general jurisdiction. But the effect principle is not beyond the territorial jurisdiction. The effect principle explains territorial jurisdiction. So, on the first issue, on the second point of first issue, the defense and the government's counsels state that the act is not an attack, and we disagree. According to the Georgia case in 2016, whether act is attack, we should take into consideration the casualties and other impacts. We also need to take into consideration whether the harm or the impact on the personnel of humanitarian assistance. So we should take into consideration the grave consequences of blocking humanitarian assistance. Continuation of a blockade led to the Marine Navy has launched the non-lethal tracer rounds, and many children in SUs cannot be killed and from the pandemic of yaws. About the third point of question 1, the Government Council has mentioned the Marines' blockade is a blockade of good faith, and we disagree. And we can see the 13th paragraph of this case. In 2015, the WHO has already calls on international attention on the pandemic of yaws. And the Government Council has amended the Marine states that the blockade lacks enough consideration, but it's not a good act of a good faith, because an international organization has already called on international community to transgress the blockade, but the Marine didn't do it, and the blockade has lasted 6 months. Many children are affected by this yaws. So we disagree that behind the blockade there's good faith from Marines. On the second issue, we have 3 rebuttals. First of all, the Article 27 of Rome Statute is not applicable in this case. It's not true, because in paragraph 36 in the El Bashir case, and the state party and the non-state party, on the head of state and then ICC has a jurisdiction, is an official announce of ICC in 2011. And in the Ukraine case, the ICC has stated that all people, including heads of state, the immunity is not applicable in ICC. On the second point, the Government Council has mentioned Ashman case. In 2022, in the paragraph 61, the International Court of Justice has stated that the ICTY and ICTR and the Article 27 of Rome Statute, one cannot enjoy immunity because of his official title. So, in the framework of International Courts of Justice, the heads of state do not enjoy immunity. On the third point of the question 1, under the Article 27, according to the Vienna Convention of Laws of Treaties, the treaty cannot create responsibilities to state parties. And according to Article 38 of the Vienna Convention on Laws of Treaties, a customary international principle is binding to a state party but the head of state immunity has already become a customary international principle. So the President Cyrex cannot enjoy immunity in this case. On the third issue, the government and defense has asked the dismissal of the case, and the victim needs to be released. We disagree. We can only dismiss the case and release the defendant when there's a huge violation of human rights or there's act of torture. But it's not the case in this marine state. In the case of Babanga, about the motion of referral, when there's a serious proceeding defects and it affects the procedural justice, the case can be dismissed. However, in this case, there's no such situation. The government's council has just mentioned protection of a physical security of a President Cyrex. And we can see the same in the case in Babanga. The President Cyrex has been led to ICC in less than 24 hours, so there's no violation of physical security of the defendant. And for other remedies or compensations, this cannot obstruct the proceedings of ICC. In the word, we take into consideration the protection of human rights of defendant, but in this case, her human rights haven't been violated. So we can achieve a balance, which is the victim should be, the defendant should be heard in this court. And this is my rebuttals. Thank you, Your Honors.
Thank you. So now the bench will
非常感谢。
Now the bench will leave the courtroom to proceed with deliberations in our chamber. And you will be allowed to leave the courtroom, but will need to be back and present in this courtroom at 11:50. So thank you, court officer.
All rise.